Good afternoon, students. Welcome to Srimada IAS Academy. My name is Gowtham. I am a faculty for Political Science and International Relations. I am also a faculty for General Studies Paper 2 in Civil Services Mains. I teach segments related to Indian polity, governance and international relations. Today, we will have a talk about the scheme of checks and balances under the Indian Constitution. The scheme of checks and balances. What is the rationale behind this scheme? We all have known that in the medieval period, there used to be monarchs with absolute powers, monarchs who wielded absolute powers. So much so that they were unaccountable for their actions. People had no choices. People had no right to question. There were no other governmental organs to impose a check on the exercise of arbitrary power by these monarchs. In the modern times, it was considered that this absolute monarchy and exercise of totalitarian power is against principles of democracy. It is against the ideas of particularly liberal Western democracy. It is in this context that the idea of separation of powers, checks and balances, they all became very prominent. To begin with, there were a good number of political thinkers like John Locke, Rousseau, Voltaire, and even a French political scientist by the name of Montesquieu, who propounded the concept of separation of powers. Please let us not confuse between the idea of separation of powers and the doctrine of checks and balances. The Indian Constitution provides for a parliamentary form of government. It provides for a parliamentary form of government. A parliamentary form of government cannot boast of any strict separation of powers. In fact, one very important feature of a parliamentary system is fusion of powers. Therefore, it becomes very difficult and it becomes very cumbersome to put in place a scheme of checks and balances within the parliamentary system. And that's the reason why the constitutional makers to blend the parliamentary system in the Indian Constitution with a foolproof scheme of checks and balances is considered as a salient feature of the Indian Constitution. The synthesis between parliamentary form of government and the system of checks and balances is a salient feature, a distinct feature of Indian Constitution. Here, we can understand the dexterity of constitutional makers in bringing about this harmonious synthesis. The synthesis between parliamentary system or parliamentary form of government and the scheme of checks and balances. Now, why do we need a scheme of checks and balances? Obviously, we all understand that we require to impose a restraint on exercise of power. And in the modern times, there are various means through which absolute power is restrained. One such mechanism is constitutional form of government. We have a constitution which becomes the fundamental law, and no authority or power can be exercised which is beyond the constitutional mandate or beyond the scope given by the Constitution. This is one way through which exercise of absolute power can be stopped, can be restrained. The second way, of course, is introducing a scheme of checks and balances. The scheme of checks and balances seek to ensure that the powers of the government are divided between the various organs, that each organ balances the other, that each organ acts as a check against arbitrary exercise of power by the other organ. This is the scheme of checks and balances. So, the scheme of checks and balances primarily is intended to ensure that there is no improper functioning of the government. To ensure that there is no improper functioning of the government. It simply means that no organ of the government will be allowed to overstep the constitutional limits. Other organs of the government will prevent any organ from overstepping the Constitution. And that's the reason why the scheme of checks and balances is an important mechanism through which we can prevent improper functioning of the government. Secondly, the scheme of checks and balances also decreases the risk or the probability of centralization of power. We all know that centralization of power can at times lead to arbitrary exercise, abuse of power, misuse of power, or using power for personal gains or self-aggrandizement rather than social good. To prevent such concentration of power in a single institution or a single individual, we require a proper scheme of checks and balances. Thirdly, the scheme of checks and balances also ensures that there shall be no arbitrary exercise of power. There shall be no arbitrary exercise of power. Arbitrary exercise of power actually means illegal exercise of power. If there is any illegality in the exercise of any power, that can be checked or prevented if there is a proper scheme of checks and balances. Therefore, this is a mechanism to prevent arbitrariness, to prevent illegality, to prevent concentration of power in a single hand, or to prevent improper functioning or misuse of power. And finally, we require a scheme of checks and balances to ensure that the supremacy of law is enshrined, so that nobody, whoever violates the law in whatever capacity, will be allowed to continue to hold any office or authority. So, to prevent the subversion of law and to uphold the rule of law, we require a proper scheme of checks and balances. These are the reasons as to why the scheme of checks and balances becomes necessary. To prevent misuse, to prevent concentration, to prevent arbitrary exercise, and to ensure a rule of law, we require to have a proper scheme of checks and balances. Now, as I've discussed a few minutes earlier, the parliamentary form of government has an important feature which is called as fusion of powers. So the parliament system is based on the principle of fusion of powers. It means there is a coincidence of the membership of legislature and executive. For example, the President of India is also a part of Parliament. The members of the Council of Ministers who are members of executive should also possess the membership of legislature. They should be members of Parliament. Therefore, there is an overlap or coincidence in the membership of legislature and executive. This is what's called as fusion of powers. And this is an important feature of a parliamentary form of government. This fusion of powers ensures that there is proper coordination between the governmental organs, and this scheme of fusion of powers also ensures that there could be prevention of any potential conflict that could arise between the governmental organs. It is for realizing these purposes that the parliamentary form of government provides for fusion of powers. Therefore, it becomes very difficult to introduce a scheme of checks and balances within the parliamentary system because there is what is called as fusion of powers. However, as I told you, the constitutional makers' dexterity lies in the fact that they have synthesized the parliamentary form of government and the principle of checks and balances. The Indian Constitution does not accept the principle of strict separation of powers because we have fusion of powers. Please remember, a presidential form of government, on the other hand, is based on strict separation of powers. The presidential form of government, as we have in US, for example, does not have any coincidence of membership between legislature and executive. It is based on strict separation of powers. Each governmental organ has its own members, its own functions, and there is no coordination and there is no cooperation or overlap of functions between these two governmental organs. The powers are strictly separated. In that scheme of strict separation of powers, it becomes very easy to incorporate the principle of checks and balances. However, though the Indian Constitution does not provide a presidential form of government, it provides for a parliamentary form of government which is based on principle of fusion of powers. The Indian Constitution still has incorporated the principle of checks and balances. It relies, in fact, on the principle of checks and balances to ensure that the power is not abused or constitutional mandate is not violated. Now, how is this done? We have incorporated a series of provisions in the Indian Constitution to ensure that there is checks and balances. Firstly, to ensure proper legislative control over executive, several provisions are introduced. For example, Article 75(3), which declares that the Union Council of Ministers is collectively responsible to the legislature. Please remember, it is the Union Council of Ministers which is the repository of all executive power. And this body is collectively responsible to the legislature. It means the legislature can, at any point of time, with or without grounds, remove the executive through a no confidence motion. That is one way through which our legislature can exercise some control over executive, some check over executive. Secondly, through parliamentary committees also, a series of executive actions are scrutinized and reports are submitted to the parliament based on which the parliament holds the government accountable for its actions. So parliamentary committees are an important tool to enforce executive accountability, to ensure that executive works within its constitutional bounds. Thirdly, there are several other tools available with the parliament to enforce responsibility. Tools like censure motion, through which government's actions can be criticized and government can be held responsible. Adjournment motion, through which the members of parliament can express their displeasure with the government through an adverse vote, which of course amounts to lack of expression of confidence, and therefore the government may resign. There are a series of such tools like quotients, no confidence motion, adjournment motion, censure motion, even cut motions also amount to expression of lack of confidence, and therefore government may resign. So all these are available with the parliament as tools to enforce responsibility. Through these tools, the parliament can enforce responsibility and hold the government under check. This is one scheme. Secondly, our executive also has certain tools in the Indian constitutional scheme to control the legislature. For example, Article 85, Clause 2B provides that the President of India can dissolve the Lok Sabha on the advice of the Prime Minister and the Council of Ministers. So the very life of Lok Sabha is dependent on the Council of Ministers. If the Council of Ministers advise the President of India, then the President of India will dissolve Lok Sabha. So if legislature can remove the executive through a no confidence motion or through an expression of lack of confidence, the executive also conversely can effect the removal of legislature by the President's power to dissolve Lok Sabha. Further, Article 111 provides the President of India with the veto power, which can be used on the advice of the Council of Ministers to stall any bill made by Parliament. The President of India is also empowered to exercise absolute veto over those bills which do not find favor with the executive. This is another tool, therefore, to enforce check on the hasty and ill-considered legislations of the Parliament. Thirdly, Article 118 provides that the President makes rules for the procedure with respect to joint sitting of the Parliament. So with respect to joint sitting of the Parliament, which is held in case there is a disagreement over bills between both the houses, the President of India has the power to make rules for the procedure to be adopted at the joint sitting. These are several ways through which the President of India may impose certain checks on the exercise of power by the legislature. Thirdly, how is it that our legislature controls our judiciary? How? Now we know that Article 124 provides that the judges of the higher judiciary, including Supreme Court and High Courts, can be removed by the President only after the address by each house of the Parliament. Only after both the houses of Parliament prefer a motion of the removal of a judge of either Supreme Court or High Courts, then the President of India may remove such judge. It means the Parliament can effect the removal of a judge. So with its power to remove a judge, our legislature can impose a check on our judiciary. Further, Article 140 says that the Parliament has the power to confer upon the Supreme Court any such supplemental powers as necessary. So Parliament can in fact provide the Supreme Court with any such supplemental powers. Of course, please remember that Parliament cannot effect a reduction in the jurisdiction of Supreme Court, but it can provide Supreme Court with some supplemental powers. So through these, our Parliament can impose some restraint or check on the exercise of power by our judiciary. And how does our judiciary control our legislature? First, Article 13.2. Article 13.2 provides for the power of judicial review exercised by the courts. Every law made by Parliament can be subjected to judicial review. The courts can ascertain the legality of a law made by Parliament and to strike that law down, to declare it null and void or ultra vires if it is violative of the Constitution. This power exercised by judiciary is called judicial review. The power to strike down laws made by legislature if they are found violative of the Constitution. So through this, our judiciary can stall or prevent any such laws made by Parliament which are in abrogation to the Indian Constitution. Further, Articles 32 and 226 provide the Supreme Court and High Courts respectively the power to issue writs for protection of individuals' rights against arbitrary exercise of power, either by legislature or by executive. And thirdly, under Article 142, Supreme Court can pass any such decree or order as is necessary for doing complete justice. So, any action, either by legislature or by executive, which does not amount to complete justice, can be stalled through an order or decree issued by the courts. So, it is through these powers that judiciary exercises control over our legislature. Similarly, how does our executive exercise control over judiciary? First, Article 124 and Article 217 provide that the President of India, through an order, appoint the judges of the higher judiciary. The President of India appoints the judges of higher judiciary. Also, Article 124 provides that the judge of Supreme Court shall be removed by an order of the President passed after an address of each House of Parliament. So, the power to appoint judges of higher judiciary is one power which is exercised by our executive to exercise some form of control or a check on judiciary. However, in recent times, because of the advent of the collegium system for judicial appointments, it became very difficult for the executive to exercise discretion in appointment of judges. Now, please remember that at the time of the commencement of Indian Constitution, it was considered that appointment of judges to higher judiciary was a prerogative or a privilege of the executive. And the role of the Chief Justice of India was merely to be consulted by the President of India when such appointment was being made. However, the advent of the collegium system had given an upper hand to the judiciary in appointment of judges. This fact, it is argued by some constitutional experts, is violative of the principles of checks and balances, because it has given judiciary a special power to get their preferred candidates to be appointed as judges, removing the upper hand of executive. This had, to some extent, according to some constitutional experts, violated the principle of checks and balances. Next, how does our judiciary control our executive? In the same manner as legislature, Article 13(2) provides for judicial review, the power of the courts to review executive actions for their constitutionality and to declare those actions as null and void if they are violative of the Constitution. So, this power of judicial review, our judiciary can control the actions of our executive. Secondly, through Article 32 and Article 226, the Supreme Court and High Courts can issue writs to prevent any executive action which is violative of individual rights or which is arbitrary. Similarly, Article 142 provides that the Supreme Court can pass certain decrees or orders for providing what is called as complete justice. It is through these measures that our judiciary can impose some form of control over our executive. So please remember Article 13(2), Article 226, Article 32, Article 142 are means through which our judiciary can control both our legislature as well as our executive. And finally, though we have a scheme of checks and balances, there are certain factors which are operating in Indian political system which are undermining the principle of checks and balances. The first one is lack of clear demarcation and separation of powers between the different branches of government, leading to overlaps and conflicts. Please remember, as I told you, that we have an overlap of membership between legislature and executive, as well as an overlap of powers between the different branches of government, which are sometimes leading to conflicts. For example, the power of legislation is given to the Parliament. The power of delegated legislation is given to the executive. So sometimes, exercising delegated legislation, the executive may bring in certain reforms or certain changes in the proposed legislation which can actually defeat the very purpose of that law, which can lead to a conflictual situation. So it is in these circumstances that we find that a conflict can arise and it can undermine the principle of checks and balances. Secondly, in recent times, it is said that the executive branch of government had begun to usurp a lot of powers. Please remember that starting from 1971 onwards, all the bills that were passed by the Indian Parliament were only public bills. It means bills which are drafted in the executive departments, bills which are proposed and which are bulldozed by our Council of Ministers, and bills which are clearly in favor of the government. Only public bills were passed. It means the lawmaking power, which originally and actually should belong to legislature, is usurped by our executive. Similarly, there is also an allegation of rise in certain executive bodies, particularly bodies like the Prime Minister's office, the PM's office, the Prime Minister's office, which has become very, very powerful in recent times. And these bodies, which have amassed a lot of executive power in recent times, are actually outside the ambit of legislative responsibility. And thirdly, it has also been observed that the advent of coalition politics also had led to crisis of accountability. The Parliament is not able to enforce accountability and not able to hold the government responsible for its actions in an efficient manner because of the coalition politics. It is these which are acting as big impediments for entrenching the scheme of checks and balances. And finally, of course, it's also criticized that judiciary had also become highly unaccountable, and the role that is being played by judiciary is often today identified as judicial overreach, reaching out beyond the traditional mandate offered by the Constitution to usurp the powers that actually belong to other governmental organs. While judiciary supports its role as within constitutional bounds, a good number of constitutional experts feel that it is judicial overreach and not actually mandated by the Constitution. It is this judicial overreach which has led to judiciary becoming unaccountable, giving it the potential of becoming more and more arbitrary. These are a few facts about the dynamics of Indian politics in recent times, which are undermining the scheme of checks and balances. Hope this video will help you perform better in your civil services examination. Thank you so much.